Okay, so here's an update to my earlier video, just a quick screen recording of what I've just asked Gemini AI regarding the Worcestershire versus Swindon case law. I said, okay, I've read a publication produced by NHS England on their Who Pays website dated the 1st of April 2024, which says in paragraph 18 that the Worcestershire versus Swindon's case law doesn't apply to its determination of funding authority based on, as is implicitly stated in the Supreme Court ruling underpinned by the legal doctrine of precedent, the basis that NHS interpret the Supreme Court ruling to be irrelevant to their allocation of funding via its integrated care boards. Who is in the right? NHS, Who Pays of 1st of April 2024, or the Supreme Court? Surely the Supreme Court, right? And this is what Gemini said. You've raised a very important point about the interplay between legal precedent and administrative guidance. Here's a breakdown of the situation. The Supreme Court's authority. The Supreme Court is the highest court in the UK. Its rulings establish binding precedent, meaning that lower courts and tribunals must follow them. The Worcester versus Swindon case clarified the interpretation of Section 117 of the Mental Health Act 1983, specifically regarding ordinary residents and the continuation of aftercare duties. NHS England's guidance. That's the main point here, is that it is guidance. NHS England produces guidance to help integrated care boards and other NHS organisations understand and apply relevant laws and policies. Their Who Pays guidance aims to clarify funding responsibilities within the NHS. It appears that NHS England is making a distinction between the local authority responsibilities under Section 117 and the NHS funding responsibilities of ICBs, Integrated Care Boards. There's a potential conflict when administrative guidance appears to diverge from established legal precedent. It's crucial to understand that legal precedent sets the fundamental legal principles. Administrative guidance aims to provide practical instructions for implementing those principles within a specific organisational context. Resolution. In situations of conflict, legal precedent generally prevails. If a legal challenge were to occur, a court would likely prioritise the Supreme Court's ruling. It's probable that the NHS are making a distinction between the allocation of funding between integrated care boards and the responsibilities of local authorities that are detailed within Section 117 of the Mental Health Act. This would be how they reconcile the two positions. In summary, while NHS England can provide guidance on its funding policies, it cannot override the legal principles established by the Supreme Court. Therefore, the Supreme Court's ruling holds the ultimate legal authority. So, if anybody can help to represent me, I can't tell my doctor to go against the guidance, or my responsible clinician to go against that guidance. But the Supreme Court has the ultimate ruling precedent there, according to Google. If anyone knows any different, leave me a like or a comment or a share, or send me an email or a tweet or an Instagram message or a fucking carrier pigeon or something, and maybe we'll get to the bottom of all of this. Cheers.